Second statement, I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carlisle, 196, Virginia at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writing should be made known to the public generally. It is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335 at 350. Everybody and his grandmother testified that Ms. Heard was referring to her bogus ex parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of this TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead. Mr. Depp, Ms. Dombrowski, Mr. Carino, Mr. Wiggum, and the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear, i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Under Virginia law, quote, it is not necessary that the defamatory charge be in direct terms, but it may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. Citing Carlisle, well, we can argue as to how artful it was, but the implication was very clear, as the court has previously ruled, or not law of the case, but as the court has persuasively written in its opinion letter. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike, but there's a lot more than that.